Recording in progress.
Thank you, Mr. Mayor. As a reminder, this meeting is being recorded and will be posted on the town's YouTube. I ask that those within the room remain quiet unless they're involved in the discussion, and that those attending over Zoom keep their cameras off and microphones muted if they are not involved in the discussion. If you'd like to speak on Zoom, please use the raise hand function feature. For those in person, please speak audibly toward the microphones or the microphone on the lectern. Before you make your comments, please state your name and the street that you live on for record keeping purposes. If this meeting gets interrupted, we will immediately end the Zoom and send a new link via email. I'll now turn it back to you, Mr. Mayor.
Okay, thank you. So this is a special town council meeting, which will be followed at the conclusion by our monthly town council work session. So the first item on the agenda is the consideration of the agenda as presented. Is there a motion?
So moved.
Is there a second? I saw Council President, Councilman Heller. Is there discussion? Hearing none. All those in favor?
Aye.
Thank you. The next item is our public comment period, which is required at any time we have a council meeting. So is there anyone, is there anyone in the audience that would like to comment about anything tonight, unrelated to what's on the agenda? And has anyone on the no one? Okay, thank you. We will now move to consideration of the consent agenda. Is there a motion? So I heard Councilor Kumar and seconded by. Is there discussion? Hearing none. All those in favor? All those opposed. Okay, now we will get to our hearing. The agenda item is listed as council review of the variance application approved at the September 9, 2024 town council meeting submitted by David Kelly for the property located at 4815 Cumberland Avenue. So now we will begin. Today is November 18, 2024. This is a hearing before the Town of Somerset Council to review the variance permit granted to David Kelly, the property owner, at 4815 Cumberland Avenue, and ensure the property owner complied with the terms of the variance decision and permit. As a reminder, 3 variances were granted for the shared driveway at 4813 and 4815 Cumberland Avenue. One of the variances granted was to expand the width of the driveway apron to 25 feet. The apron has been constructed to a width of 24 feet, but a resident has asserted that the pre-existing apron width was not accurately represented, and as a result, excess width has been constructed. We ask that residents be limited to 1 comment each, and that they be limited to 2 minutes at a time. When you speak, please state your name and street before you make your comment. When your time is up, a buzzer will sound and you'll be asked to please finish your thought. If you wish to speak on Zoom, the deputy town manager will call on residents by listed name with the last 4 digits of the phone number if no name is provided. The hearing will observe the following order. First, the Somerset Town Attorney will provide an informational report. Next, the property owner will have an opportunity to speak. Following that, the Town Council will have the opportunity to ask questions of the property owner or staff relevant to the variance and permit at hand. Following that, other interested parties will have the opportunity to ask questions of the property owner or present comments to the council. Then, if necessary, the property owner will have the opportunity for rebuttal testimony, after which the public comment period of the hearing shall be completed and the record closed. Finally, the council will deliberate and discuss among themselves the merits of the case, the findings of fact, and conclusions. The council may make a motion on a decision. If any opposition is presented, the town attorney will be asked to write a decision, and a time of 30 days will be allowed for an appeal. If no opposition is presented, the town manager will be asked to execute the decision. We now begin this hearing with the presentation by the town attorney.
Thank you, Mr. Mayor. So the question presented for the council tonight is whether the variance decision has been complied with. And I'm hearing an echo. Are you hearing an echo?
No.
Okay, see what.
It's suggested that you turn it down.
Is the microphone on?
Oh, the microphone is on. I don't know, yeah.
Thank you.
Okay, yes, yep, that did it.
Is
That's
that
better.
better? Is that better?
Yeah, thank you, Mr. Mayor. So in a nutshell, as the deputy town manager noted, the town council granted a variance for a driveway apron with a width of 25 feet. And there was, I believe, some misunderstanding, at least on my part. I understood the existing or pre-existing apron was 20 feet. And the variance was described in the notice to the public as an extension of the driveway apron along Cumberland Avenue from 20 feet to 25 feet. And I understood that to mean the existing apron was 20 feet. As the building permit administrator has explained, that was meant to indicate that the driveway apron standard applied by the town is 20 feet. And so the variance was sought from that standard of 20 feet and was not meant to indicate the width of the existing driveway apron. So the question for the council to resolve is if the council similarly misunderstood how the request was being presented, would the pre-existing width, which was only 14 feet, not 20 feet, have a difference in the council's decision in applying the variance criteria as to whether the variance should have been granted? I will note that 20 feet is allowed by the code, so a variance would not be required to go from 14 feet to 20 feet. But the variance is needed to go to 25 feet. This issue did bring to light another problem. So as the council will recall, a condition of approval of the variance was that the applicant and the adjoining neighbors sign a right-of-way use agreement for the extra width for the apron, such that should the council in the future want to reclaim that right-of-way, perhaps to put in an ADA compliant sidewalk, as we discussed at the hearing, the town would have the ability to do so, and that would be reflected in the agreement. That agreement was supposed to be negotiated and signed before a permit was issued. So that agreement has not been returned, and the permit was inadvertently issued and the work completed. And I note that pursuant to the last hearing as well, because the plan included a water drainage plan, the water drainage plan agreement was supposed to be returned before a permit for the rest of the work was issued, and that didn't happen either. So the variance could be deemed void for failure to comply with that condition precedent, that the right-of-way agreement be negotiated and returned before a permit is issued. And that raises the question in my mind as to whether that condition is even possible now, because as I noted at the last hearing, now that would require the neighbors' consent. The neighbors did consent at the last hearing, but apparently they were under a misunderstanding about the evidence as well. I'm happy to answer any questions the council has. And I did ask that the record include a copy of the site plans that were submitted with the application so that we could discern the prior apron width and the proposed apron width as represented by the applicant. Because it appears to me that I think it could have been a good faith misunderstanding on everybody's part. I don't see in the record myself that the applicant ever represented that the apron was 20 feet wide. I listened to the recording of the last hearing, and Councilmember Rovak asked a question, basically, how much is the apron going to be expanded? And Mr. Kelly walked up to the screen and pointed to the site plan on the monitor and said the prior or the existing apron starts about here. But I don't believe, he said it was 20 feet, 14 feet, etc. It was just pointing to the screen. And that concludes my report. Thank you, Council.
Okay, thank you. Mr. Kelly, you now have the chance to address the council, and thank you for, and if you could use the, we'd appreciate it.
Probably could turn on the mic.
For the folks that are dialing in. There's a light that comes.
Thanks for taking the time tonight. I guess I'm a little confused as what is the issue here? I came before you all to get the variances and for the increased width of 5 feet. And the existing apron, the drive, not the wings, but the part of the apron which attaches to touches the property line. Well, in this case, the property line's good 8 feet from the end of the former concrete and the current concrete that was placed. And then using the town standard, which the engineer supplied to me, which, and the variance allowed me to do was to build the standard 10-foot wide easement or apron at the property line and put 5-foot wings on either side, bringing the total apron to 25. I met with the town engineer when the construction started with the apron across the street, and we looked at that as the model to duplicate. It was a little different from what was there before. The radiuses were much shallower. So on the old existing apron, they were rather radical, semicircular in shape. But nonetheless, concrete at the 7 feet off of the property line is 15 feet. We widened it by 5 feet, and the wings are 5 feet on either side. So bringing a total of 25 feet. And in this case, the easement, the driveway easement, which we created 6-8 months ago and then revised at the neighbor's request, the boundary of that happens to be on the landscape side of a kind of a decorative or retaining stone border between the gravel driveway and the landscape. And it is actually about a foot, the easement projects about a foot beyond that stone. So when we built the easement with the apron, had a consideration for the way the neighbors use their landscape, had that stone there. I made the new concrete a little shorter, a little narrower than what was permitted. So I believe it measures 14 feet, maybe 14 feet a few inches at the 7-foot line from the pavement, and from there I went to the 5-foot wings for the apron. And that is what the town standard, the town engineer guided me to do. I've seen some photographs before the meeting that were posted as part of this agenda. And I guess the discussion that we made it 5 feet bigger, and I thought that the one photograph showed our new concrete with some flagstones placed, trying to represent what was there before. And I would just like to note that whoever put those stones there kind of exaggerated what was there before. It's very clear that if you look at the condition before we did our work, you can see where the old concrete curb and the flagstones just behind it. There are 2 large stones starting to the left of the big town tree, And it ends right at that joint where the new concrete meets the existing old concrete. Well, the person who made that photograph shows 3 large stones, a small stone and a radius stone, which really is I guess an egregious representation of what was there. So, I think that's all I can say at this point. I will listen to other testimony and see if I need to have a rebuttal.
Okay, thank you. And if you could stay there so people can see you. And Mr. Kelly, if you could stay there so people can see your. Before I turn it over to the council, let me ask the town attorney, do you have any questions of Mr. Kelly?
No, Mr. Mayor.
Okay, thank you. Council,
No, I
Sure.
want to add one
Sure,
more thing.
please do.
Mr. Barr, both mentioned that there was an easement for a future sidewalk that might be placed. And it was my understanding that was going to be generated from the town, that was a requirement from them. And I never had seen anything or never got a notice of who was supposed to present it and create it and what it was supposed to say. So I thought that was just something that happened internally within the town government.
okay, thank you. Council President Barr, do you have any questions?
Okay, I do have a question, but I'm going to start with what was on your application in August, because my read of your application is that you've actually done what you said in your application.
I'm sorry.
That you've done, I'm going to read your application, a piece of it, and I think you've done what you said in your application. So I'm not going to complain about that. So to replace the existing shared apron, I am requesting a variance to construct a new apron with dimensions 15 feet at 7 feet from the curb, and you said it's a little bit under 15 feet at the moment, right?
Correct.
With additional 5-foot wings on each side, which are the concrete wings going to the street. The apron will be concrete, and that's it. And so that's what you built.
Correct.
All right, the question relates to the bit that you described earlier. You apparently, your contractor disturbed the landscaping of your neighbors when laying the concrete apron on the 4813 side. And I'm sure we'll hear from the neighbors over that disturbance, but did you notice that disturbance yourself?
I did, and the right of way, the town engineer directed us to do the apron in which manner in which it was built, and the right of way takes precedence over what the neighbors choose to put in the right of way. We ran into a similar issue with Pepco across the street when they ran power. The neighbor there had planted a large collection of shrubbery which grew 4 or 5 feet tall, and we had to remove those to be able to get the electric to the house. She understood that. She knew it was, she was taking that responsibility when she put the plants there. And I think everybody who buys that house anywhere knows that the public right of way is public.
Given that, though, would you agree that it's fair to notify the neighbors that you will be removing some of their landscaping?
I've had several meetings with the neighbors, and I'm starting to put red paint on the existing curb where we were going to do our work.
That you think was sufficient notification?
I didn't know how the wings were going to be until the town's engineer pointed at the apron across the street and said, "This is how we want it. It's not going to be a radius, a tight radius like was there before. It's going to go have a square curve and taper down into the drainage pan, and then curve up from 5 feet to 7 feet off the property line, which is 15 feet. In this case, it's like 14 feet or 14 feet or something."
Okay, that's all the questions I have for the moment. Thank you.
Councilor Circa.
Thank you. Yes, I have a couple of questions. Start off with Ron. Can you just verify my understanding that the variance required a document to be signed by by owners of both properties, 4815, 4813?
That's correct.
Right. So my question for the 4815 is, if you knew that this document had to be signed, that you had to sign this document, and you didn't see that document, why did you think you could proceed without signing the document?
No, which I don't know.
Okay, thank you. And this, for the town manager, just to clarify my memory, is this the project where there were some trees cut down without permission? Okay. And I had a question about the drawing, hard to show, but when I look at it, the only place where I see a change in the radius is to the 4815 side of the driveway, where there's this extra sort of C shape, U shape drawing in.
Well, this
here.
is the existing,
Right,
and that is, I'm not sure what this is. This plan is a site plan, which, the apron, and we'll see a copy of that here. But,
well, we have electronically with the towns.
yeah, that's what that was part of the application. That's what was gonna be this new concrete.
Okay,
So that hard circular radius there was not gonna be reestablished unless the town wanted it. Then, you know, they were talking about the trucks and moving vehicles coming in and out of lots this didn't perform well.
okay,
And that's why it was changed to adopt the county standard
Okay.
for aprons.
thank you. That's all the questions I have.
Councilor Heller.
Someone correct me if I'm wrong, but when I was reading through these documents to get a handle on tonight, there was something there that said that before you did actually poured the concrete and did the driveway, that the neighbors were supposed to be on hand. Am I wrong about that? Anybody else read that?
Ask the town attorney.
Yeah.
Ask the town attorney.
Okay, so in that case, you didn't do that. And might we not be here tonight if you had actually involved them like you were supposed to and have them there? And then that all could have been hashed out before any harm was done by, you know, the work that your people had to do and so on. So that's.
So Councilmember Heller, I don't believe that's a requirement of the town, but it was in an agreement between the parties as evidenced by the email in the record. And I mean, so the emails speak for themselves in the record about what transpired there.
So I think that was a major blunder on your part, not having them there like I guess it had been.
Well,
agreed
I
on.
had many meetings with them about the
I
driveway.
know, but that's not what what I read. What I read was that you had agreed that they would be there when you did the apron. That's what I understood. Am
Well,
I wrong in my understanding, guys?
I had a phone call with them, or a couple of text or emails, I don't remember now, but saying we were gonna do it on Tuesday, and they said, well, we're out of town Tuesday or Wednesday. Back on Friday, and do it Friday, and I said, I think that'll be all right, let me call my contractor, and in the construction business, you know, it's important to get your people there when they have the time to do it. Otherwise, weather comes in, delays, scheduling, so the neighbors said that they were gonna be back on Friday, and we would wait till Friday. I got a call Thursday morning from the concrete company, and they said, we can do it today, and I said, well, I'm supposed to do it tomorrow, but if today's today, let's do it. I'll send them a note, and I don't know exactly what, you know,
So you
what
didn't
it means
do,
if they're out of town or
So you
gone or
basically-
whatever. I just let them know that we were proceeding, and
but you basically didn't follow through on what you originally agreed on because your concrete guy called and said, I can come today. And I don't think we'd be here today if you'd said to the concrete guy, I gotta hold you off until next week. You're not gonna be available until tomorrow. Can you come tomorrow? Can you come next week? I think that's why we're here tonight. Okay?
I apologize for that. I'm not sure anything would change from the town standard, you know, you have a standard by which we have to build.
No, but I think it would have, no, I think it would have been different. I think had you had them there like you agreed on, you know, we wouldn't be here tonight to talk about it. And I think you would have come to some agreement because you would have showed them what you were thinking. they might have gone, well, okay, no, yes, no, I don't know, I'm not part of this. But, I think that is what's at issue tonight and what's at fault on your part, that you needed to follow through in what you said you would do. And that these things can't be slip and slide, like, okay, today we can do it, tomorrow we can't. When you build something in a town like this, you have to follow what you say you're gonna do. That's all.
Well, I mean, the fact of the matter, this is the public right of way, and what I wanna do, or what the neighbors wanted to do there is, a moot point, because we have standards we have to build to.
I understand, but the
Now,
fact of
we
the
built
matter,
those standards.
I understand, but the fact of the
So-
matter is, you didn't follow through with what you say you did, and that's that. That's all I question.
Okay, thank you, Councilman.
Thank you, Mr. Kelly. I have two questions for you. You just mentioned that you built to the standard. So let's say the outcome was 25 feet wide apron. Could you have achieved that by not disturbing the neighbor's side of the apron at all? Could you have expanded the apron just on your end and achieved the 25 foot outcome?
Well,
And met the standard? I'm not being, it's sort of a facetious question. I'm technically wondering if that was possible.
no, I hear you, and you look at the drawing that you have before you, and it shows that kind of a.
Yes,
Circular radius, that was going away.
that's on your side.
No, it was.
This one, right? That's on your side.
It was this one here.
Yeah,
That was going away. That's
that was going away. That was, okay. Why did that have to go away?
It was all part of the poured concrete, part of the shear apron.
I see. But could you have
And the
expanded?
curved apron was being changed to a truncated apron.
So there are two things happening here, is the width of the apron and the design of the apron. And the design of the apron meant that it had to go away, the curved edges of the apron.
Yeah, the town.
I'm generally wondering, is that
Leave that
correct?
piece there, it would not be an acceptable solution for an apron.
Understood. Ron, is that correct, what I just said, or?
What you said is,
Wondering-
what you said is correct, Councilmember Kabir. But I do believe the town would approve a curved or truncated apron. You can have either standard. I believe Doug is on the line and will correct me if I'm wrong.
Okay,
Well, back to your question, the radius here.
my question is very simple. If the end result is a 25 feet wide apron, could we have achieved that without disturbing the neighbor's edge?
Well,
Okay.
where that circular old apron ended,
Yes.
that's where we started. We didn't go any further than that.
Okay, well, because the.
So that was coming out, we were replacing it with the accepted design.
Because the images, I can't share this with my colleagues, but the images suggest that you went beyond what previously existed.
That image there, where that new concrete is where this point was, right here.
But
This
what
is-
about all this stuff? So, I'm looking
Well,
at
that's just
this,
part of the construction of the
I'm
apron.
looking at this. So what I'm just wondering is, could you have achieved the 25 feet by building more on this side and keeping that as it is, untouched?
It wouldn't have made any difference, we're going from where this existing apron was, that had to come out. That's 8 inches of concrete that is part of the town right away. It has got the curb in it, the gutter, it goes from the pan where the water flows into a curb and then a radius on it. So that all had to come out, and it came out right to here, and that is this point where we started.
So to answer my question, you're saying,
Okay.
no, you could not have constructed 25 feet without disturbing that side.
Right.
Correct.
Okay,
The only caveat there is that from this point, we have to get to this point. Now, what the town would allow,
well, I'm
that's
asking
not what
because,
our design criteria were.
I'm asking this question because it's less about whether variance was, it's about how you went about. And so we're trying to understand if you were given the variance, could it have happened differently? I'm not sure if I'm fully satisfied with that. Doug, do you have anything to weigh in here?
Yeah, just a couple issues. the town's typical section only shows truncations. It does not show a radii on either side. Second, it might help to clarify that
Doug,
when you
I'm so
construct-
sorry. I did not understand that last sentence. I apologize. I do know what the radii is, but
He is correcting me and saying that the town does not approve curved radii, approves only truncated angled aprons.
okay.
well, I'm not correcting Ron, but I'm just pointing that out.
That's a correction. I accept it. Thank you.
Okay.
Okay.
The second thing is that when you would construct this apron, you would start at the eastern side of the existing driveway and construct a 5-foot truncation going to the east. You don't begin along the curb and move to the west because you have to hold the existing side of the existing driveway. And that created the 45-foot, 5-foot truncation that we're talking about. When I looked at the existing plans and of the driveway apron and what was built, that starting point along the curb appeared to be within an inch or two of the same location from the radius to the truncation, if that helps.
That helps. Let me.
Well, and Mr. Lohmeyer, is it correct that you've observed the current seam between the curb and the truncated apron, and it's your opinion that that seam is or is not the same seam as previously located? Does that
I'm
make
sorry,
sense?
I didn't say that again.
So
I didn't follow you.
when the circular apron was removed, there was a circular section of curbing, correct?
There was a radius there, yes.
Yes, so the curb was curved in a radius,
Yes.
correct? And
Yes,
that section was removed, correct?
Had to be, yes.
And there was a seam between the straight portion of the curb and the curved portion of the curb that was removed, correct?
Yes, about 1 foot section, yes, which was put back.
Put back with a truncated curb, correct?
No, from the photograph I took, it appears that they put back 1 foot of straight curb before they began the truncation.
Oh, okay. You okay. 'Cause during our meeting with Miss Kaplan, you had said that seam was the same seam as before, but now you're saying,
It's not, it's truncated. It has to be.
Well, I'm saying the seam 1 foot back from the truncation is the same as before,
Yes.
not where the truncation was.
I see. As in on the outer, I see what you're saying.
so the seam has not changed. Is that what you're saying? That's what I'm getting at. Has the seam changed location?
Yes, I think so.
It had changed.
Okay, we'll come back to this. We'll come back to this. I think I've established where I wanted to. I had a second question, which is that do you believe that you mischaracterized the original width of the driveway in the original application?
Did I do what?
Mischaracterize the pre-existing width of the driveway in your original variance application?
No.
Do you remember what you characterized that width to be?
I only have what was on the engineer drawing.
Do you remember what that was?
I assumed it was 10 feet. And, I may have measured it, but I didn't write it down, I didn't note it, but I was going to build what was allowed, what permitted.
No, I appreciate that because part of the confusion here is that I remember that because you walked up to the screen or we made you walk up and explain. And we were going off drawings that were shared with us. And those drawings characterize the width at a certain length. And so I was trying to understand, was that accurate with what it was actually?
Do we have
In your understanding,
drawings?
in your understanding, was it accurate? So yes or no question?
The drawings that were,
Yes.
yeah, should have been accurate.
Should have been accurate. Okay,
Engineer drawing.
thank you.
Thank you, Councilor Rovak.
So, okay, so just so I'm clear, so the existing driveway was 14 feet wide. right?
Apron, I think the existing apron.
Apron was 14 feet wide.
As,
Was the existing?
Yeah, the site,
apron?
the boundary survey indicates it was approximately 14 feet wide, yes.
And so, but our town allows an apron to be 20 feet.
Correct.
And so I guess that, why did you need a variance for 5 more feet? Because it was already gonna be increased from 14 feet to 20 feet. Why do you guys need that extra 5? Like, why was there even a variance on this?
The entrance into the properties was very small. There are a overgrown shrubbery right up to the corner of the street there within 4 or 5 feet. You can't even see the street when you're on the apron. If you're backing out of the driveway, you're in the street before you can actually.
But I mean, that's on the existing driveway, which was
Exactly.
14. So you
Well,
had approval to go to 20.
I'm not gonna say yes or no, it was 14. I don't know what it was. I would have to call the engineers or verify it on the site plan, because they were the ones.
But I mean,
who platted it.
we none of us really truly understood what the existing driveway was, because like we don't go around carrying measuring sticks and whatnot. And so I guess that you have the approval to widen the driveway already just by, or the apron, just by the various degree of what it was. But yet we have to take it 5 feet further. And I feel like it was very miscalculated, like in terms of how, you know, it all went down. I'm not saying that it was your fault. I'm just saying that, you know, when I asked the questions about taking away parking and things like that, nowhere did anyone tell me that, oh, well, they're already going to be, you know, just by the sheer nature of it, it's already going to be widened 6 feet. And then this variance is 5 feet more on top of that. So like that was never explained anywhere in any of these discussions. And again, I don't blame you. I blame the whole situation. But I feel like it was really mischaracterized in the hearings before. Did you paint the red and show them the red of like where the driveway would be, or the apron? Sorry.
Yeah, they were, there, Russell was at least there, I guess. They were both there, that, we pulled the tape measure, I marked the existing curve with orange paint. And maybe it's still evident in some of these photographs, it's showing the limits of where the apron was, and they came before you guys and endorsed our widening it, so. Yeah. I showed them, I explained to them. I had the variances as requested to make the concrete only 7 feet, and from there to the property line, make it gravel. Yeah.
Okay. I don't need further.
okay, thank you. I'm gonna run through the council again. Council President Barr, do you have any further questions?
No, I've got no further questions at this time.
Councilor Sir?
No.
Councilor Heller?
Just have one clarifying piece. When I asked, and I've asked the deputy town manager to give us the original application. Because what we're trying to ascertain was in the original application, was the apron described at 20 feet or at 14 feet? Because it turns out that it was originally 14 feet, as is in reality. And so if it was characterized 6 feet short of that, I think that would have probably impacted, you know, our variance conversation, because that's significant footage for us to consider in the overall consideration. So when you said 5 feet wings, I remember you explained, you gave me confidence, but you know, were we doing that of 20 feet or 14 feet is what I'm not sure of.
We were doing it off the town standards.
Well, we were doing it of drawings, and what the drawings, we were not doing it of town standard in our discussions. We were doing it of drawings, and were the drawings characterizing it as it was, or was it at 20 feet? If it was at 20 feet, then you know, we stand corrected.
Okay.
But if it was at 14 feet, then I think that's what was on our minds. And that would be important to determine whether the drawings showed 20 or 14 feet when we had that conversation.
Well,
So I was
that I
again
don't
going to ask you,
remember. I
okay,
wish we had the drawings here.
we're going to get the drawings, we have them, yeah.
Okay, but the process here, the engineer sketches of the apron, all of the area within the town right away, you didn't ask for any permission to do anything there except stage the work in order to preserve the cherry tree. You know, we didn't ask for any.
No, I understand. I think all we're trying to determine was from which starting point was in our collective decision-making, did we give the variance for? And I think there's a departure there, that we might have given it from a different starting point than what was understood. That's number one. And number two is, once given the variance, how could it have been executed? We have highlighted different ways it could have been executed better. One of the other ways is that you could have expanded the apron without messing that side of the property, potentially. That's what I was trying to ascertain. So I think those are the two dimensions on our minds as to whether that warrants us revisiting this. Anyway, no more questions, sorry.
Okay, thank you. Councilor Rovak, do you have any further?
No.
Okay, thank you. So now, this is the opportunity for other interested parties. Will have the opportunity to ask questions of the property owner or present comments to the council. And also I will, after each interested party comes forward, I will ask the council if they have questions of that party. So thank you, Mr. Kelly, for now. So who's next? Please come forward. Remember to tell us your name on your street. Thank you so much.
Yes, thank you. This is Russell Green. I live on Cumberland. I'm the owner of, along with Jamie, of 4813, which is the next door neighbor to Mr. Kelly.
And remember, you have the opportunity to ask questions of Mr. Kelly or,
Yeah, thank you. I noticed that we have a 2-minute limit.
well,
Okay. Because
I don't think there's.
you also mentioned that there were that it's the property owner. It wasn't clear where the shared driveway, whether it was the applicant or the both property owners of the shared driveway. But anyway, as long as we're being flexible,
Thank
it
you.
doesn't matter.
Yes, yeah.
Okay. So I did have a couple of questions for Mr. Kelly. First is that you testified that you didn't know how the wings were going to be until the town engineer told you how the wings were going to go. And I'm wondering, when did that discussion happen? Because I know we had a discussion, and my memory of the discussion is different from yours. And I'm wondering whether you talked to the engineer before or after we spoke.
Well, the way aprons are built is you meet with the town engineer, the county engineers, and they tell you how they want it done. You have a standard by which you go, and then they make the decision of how the finished apron's gonna go, where the expansion joints go, where the expansion joints will go, and where the weakened joints go. So, yeah, it's done, it happened that morning. That's when I met Doug out there and
The morning of the
construction.
Of the construction. Okay. So that's an important point, because my memory of when we spoke is, yes, indeed, you marked with paint. And my recollection is that the entire extension of the driveway was marked on your side, on the 4815 side of the driveway. And at no point did you indicate that it was going to be wider on our side. At no point did you indicate that it would cut across our hardscape. And had you done that, I think we would have had a discussion about ways to not do that. And I wish that we had that pointed out to us ahead of time, so that we could have discussed other ways to build this, because we did not object to the driveway extension, the variance, in part because we had no idea that it was going to extend on our side of the driveway.
But the start of the apron didn't go any further than the old one. The shape of it changed.
So I dispute that. I mean, we can disagree on that. I think that in the drawing, we've measured quite clearly, not the curved stone. You're right, the curved stone was not part of the original real curve. But the other two stones is where you can see measured 3 feet, which is, you know, extending, and so that essentially the straight part of the curb was shortened by 3 feet, in producing that wing of the driveway. And then just remind me, what was gonna be this is, I think, an important point, is what was gonna be the plan if you had not gotten the variance for the driveway? What was gonna be the plan for the apron?
I think one step at a time, I was gonna decide what happened if you didn't have a variance.
Okay, fair enough. I think I remember from our discussion that you said you were fine to leave it as it was. So I think I want to make 3 points. Thank you for answering that. I want to make 3 points. The first is, in my mind, this all hinges on what was the reference point for the variance. And the key is when you were approving the variance, what in your mind was the reference point for the variance? And in my mind, and in Jamie's mind, as we were supporting the variance, the reference point was the existing driveway. And I think if you read our testimony that we submitted electronically, there's a lot of reason to think, both in the language of the application and in the discussions that we had before that, in the testimony, even some of the testimony, although I admit it was not 100% clear, but I think even in some of Mr. Kelly's testimony, there was an implication that the reference point was the existing driveway. And so I think that's really the key question here today, is what is the reference point? Is it the town standard, or is it the existing driveway? And then the last point that I would want to make is just sort of to apologize to you for bringing you here. I am so tired of having to mess with the shared driveway. I feel like I appreciate your efforts at the original building permit application hearings to try to protect us from having to deal with the shared driveway being messed up. Our whole objective in this entire process, I think it was very clear, was that the shared driveway was very nice and we just wanted to keep it that way. During COVID, we had spent quite a bit of money, on the order of about $10,000, to make the driveway really nice. Our neighbor at the time, Lori Barse, provided us with a nominal $100 contribution to that to make sure that it was still a joint project. But essentially, we invested $10,000 to make the driveway really nice. It was exactly how we liked it. And we were hoping that we were going to be able to just lock it in through this permit process and not have anything changed. And it is just so frustrating to be here today, you know, given that we, you know, even tried to arrange to be able to be there to protect our interests during the pouring of the concrete, and then, you know, they didn't happen. So I think that's all that I want to.
Okay, thank you. Council President, or do you have any questions?
Yeah, Russell, your landscaping on your side, did you know, or do you agree that your landscaping was in the right of way of the driveway rather than on your own property?
Yes, I think, I'm not a lawyer, so I don't understand. I've heard Mr. Bolt describe that it's technically our property, but the town has an easement that gives it the right to do whatever it wants, but, the language is not important here. It's definitely that it's within the area that the town can do.
All right. Had you read the application that Mr. Kelly submitted in August?
Yeah, so it's interesting that you asked that, because we were provided the application that was only the letter from the engineering firm. Today, BJ provided us with the additional handwritten thing, but that was never provided to neighbors prior to today. So the only part of the application that we had at our disposal was the typed up version that came from some contract.
I mean, we'd have to go back to the meeting, but the materials, including the handwritten application, are usually displayed on a public site before the meeting so that it's available for everybody there. You may not have seen it there if possible, but I think it was available.
Hold on a second. So this document, this should all be. So you have the document.
It's in the packet, the original variant.
Because we should make sure that everybody has access to it, council over.
Yeah.
Okay, sorry to interrupt. Sorry, Council President.
And I wanted to hear your account of when the contractor laid the concrete, you weren't present. What in your view happened there?
Yeah, I mean, I think the email sort of speaks for itself, but essentially I had emailed Mr. Kelly on the 15th saying that we weren't going to be available until the 18th, and could he wait so that we could be present when the work was done. It was not just the apron, but also some of the gravel.
Okay.
On the shared driveway. And I also then further said, you know, can you verify that you're not going to move any of the hardscaping, the stones specifically? I don't think I was referring to the flagstones, but to the sort of decorative stones lining the driveway. And he said none of the stones would be moved. And so then on Thursday morning, when I was at work and Jamie was out of town, I got an email that said, instruct you, we're going forward today. Welcome to my wall. And that was it. All right, we came home and it was done.
All right, thank you. That's my questions.
Okay, thank you, Councilmember Circa.
I don't really have any questions.
Councilmember Heller.
I don't have any other questions.
Okay, Councilmember.
I have a question. I don't need to.
So, I'm sorry, but, so you requested some information, so let's make sure that everybody.
Yeah,
Why don't you go into that again?
I requested the original variance application, but Justin has told me that it was already in our packet. So it is in our packet.
The application is there, but not the site plans.
Not the, okay, so can someone upload the site plans, whoever has them? To the packet?
Yeah.
So we should make sure everybody.
Ron,
has
maybe
this.
you have them. You can-
I don't, no, that's why I asked for them to be included in the record. So
Russell,
I don't know if they're currently available in PDF format. I had suggested that, we could scan
even if
just
they
a
are hard copy-
portion, or you could roll out the full-size plans on the table too.
Yeah, I
Yeah,
can
let's
do
do
that.
it.
Yeah,
Yeah, why don't you do
absolutely.
that?
That's
Okay.
Okay.
Be right back.
So
So go ahead
Russell,
with your question.
yeah, I have one question. I don't need to put you on the spot,
Mhm.
but this is not constructed.
Yes.
What, in your opinion, would be an ideal outcome for 4813?
I mean, I think I would like to see, my side for sure. brought-
Restored.
Well, I mean, if you're not allowed to have, I don't know how this process works, but yeah, ideally, yeah, I'd like to have my side restored. So that the sort of hardscaping stuff that we had before, whether it was in the easement or not, everybody invests some amount of money in maintaining, it's our obligation to maintain that easement.
Mhm.
So that can go back.
And if that's not possible, what would be the next person?
No, I have to talk to Jamie about.
Well, hold on, you have a chance.
Sorry. If
You
it's not
need to
possible,
answer, but between the two of you, you can't say whatever.
if it's not possible to change the current concrete apron. I don't know what else I would.
Okay, thank you. I'm good. Okay, good.
You're good, okay, so, but you want everybody to.
Yeah, whenever it arrives. Just put it here.
So if anyone, everybody has the opportunity to answer. Okay, Councilor Rovak, do you have any questions?
Can I just
Mr.
ask?
Green,
Yeah,
Mr. Green.
so, this picture. Just a picture. So is this what it looks like now?
The flagstones aren't there.
Okay.
We
So you just put them back
we put them
there.
in the backyard. We only place them.
This is,
there
I
because
sent
You,
the outside.
you,
I
you
sent-
might want to show that.
This is so weird.
It's
We
Yeah.
have that,
like,
we have that
old-
in the
It's in our
packet.
packet.
It's in our packet.
Oh, okay.
Okay.
Before and
Yeah,
after.
and Ron
pictures
knows.
Before and after.
There are too many conversations going on right now.
Right, I'm trying to, so Councilor Rovak, can you let the town attorney know what picture you're showing?
Okay, let me tell you. He add one more stone there, but I remember there. that
Ron,
stone
it's page
been
24 of the
there for a
packet.
Long time. Stone. had
Okay,
one
so
more
hold
stone
on.
they added.
The-
If you go measure the never like.
Got it.
So,
Right here. So these stones are gone.
but wait a minute, you're asking, this is
Okay.
for later. Who's your question to?
Well, I was just asking Mr. Green if those stones were still there, but that the
Okay, so
picture
does
is a
Ron understand?
representation of what it did look like. He must have placed them back in, so it doesn't actually look like that right now.
Correct.
Got it. Okay.
And that's the photograph I referred to in my statement earlier, that is not correct.
Okay. Okay. Got it. Got it. And then was there any, like, did you guys have any sense that the driveway was going to be widened by that much?
I mean, when we supported widening the driveway, it was very narrow. And when we were out there with Mr. Kelly, he painted off like how wide he was suggesting make it on his side. And we were okay with that
Mhm.
line.
And did you think that those flagstones on your side were gonna be removed?
Not at all.
Okay. Okay, I don't have any other questions.
Okay,
Yeah,
please come forward.
so,
Remember to identify yourself.
Jamie Kaplan. Jamie Kaplan, I am the owner of 4813 Cumberland Avenue with Russell. So just a couple things that I wanna point out to. I think Mr. Kelly mentioned the August 3rd meeting, where he showed us that there would be the expansion of the driveway. So at that time, when he showed us the expansion, it was an expansion of 5 feet. And he showed us how that would expand on his side of the property. He mapped that out, he's right, he had a tape measure showing us the 5 feet. He had paint, he sprayed 5 feet on his side. There was no tape measure that went onto our property. There was no paint sprayed on our property. And we were led to believe that this apron was gonna expand 5 feet onto his property as the driveway was gonna expand 5 feet onto his property. At that time, Mr. Kelly also explained to us, he wasn't even sure if he needed a variance. He was like, variances are expensive. I've got to pour concrete. If I don't get if I don't get my variance, I'm just gonna leave the apron as it is, because if I touch the apron, if I touch the driveway, I then have to redo the apron. But if I don't do any work, I can leave it as is. So the discussion we were having with him is have the variance, it'll expand by 5 feet, or we could leave it as is. It's an old driveway. It wasn't like the most beautiful apron, I would say. But we were like, okay, we could probably live with that. So that was the starting point. When Mr. Kelly submitted for his original application to get his building permit, if you go back and you look at that, it actually shows the driveway staying as is, but he has on it written concrete. And we brought up during the council meeting, is concrete being poured over all of this driveway? And he said no, that he has agreed that the driveway, they have a shared easement, and the easement would supersede anything, and that the driveway will remain undisturbed. So I'm a little bit confused myself, as I think everyone in this room was confused that there was ever gonna be a driveway apron of 20 feet. That number has never been thrown out to us. It was never discussed with us. So the starting point of an existing driveway, to me, existing means it has a physical presence, or it has a presence in a plan. If it's not in a plan, if it's not physically on the driveway, I don't understand why that is being used as an existing drivable driveway. I think the town attorney was confused. I think Doug Lohmeyer was confused. I think all of us were confused. I think the only person who wasn't confused was Mr. Kelly. The one thing I will say is, Mr. Kelly, you're selling a $5 million home. We do not have a $5 million home, but your land and my land are just as valuable. This is our third, it sounds like there might be a fourth go around of you wanting to take land and convert that into shared driveway or something that you will be using. Our home is our retirement, and while there might be a measure to think, I'll do it and then see if they go after me. We've had many conversations. I'm not interested in like continuing to pursue these actions where you're looking to convert existing land into part of a driveway. So I hope this is honestly the last conversation we have, because I heard you reference earlier that part of the stones are actually part of the existing gravel driveway because of the easement. The easement is written for an existing gravel driveway. It is not written for any conversion into a driveway. I think that those are my last points that I have to convey.
Okay. Did you want to respond to that, or you will have a chance to rebut? Did you want to answer that question? If you could say this, if you could say, so you can get questions from.
What is the question?
Well, did you have a question, or is that just a comment?
I think it's mostly, I guess, I guess my question is, do you remember at that August 3rd meeting when you met with us, when you marked out with your tape measure, do you also remember, I guess, how you explained that if you didn't change the driveway, that it would, if you didn't get your variance, it would stay as is? I guess it's a yes or no question.
I would say no.
You don't remember? Okay. I remember clearly. I took notes during the meeting.
Okay, thank you. Council President Barr, do you have any questions?
Jamie, had you read the handwritten application that was submitted with the original filing in August, that where he says replace the existing?
You know, what I read very carefully was the notice that went out to the town explaining what his variance was seeking. And the first sentence here says, this variance is to widen the driveway apron from Cumberland from 20 feet to 25 feet. There is no existing apron of 20 feet. So, of course, he met with us, he showed us his 5 feet. This says 5 feet. And also, I think the point for us is, you know, we want the landscaping restored, but it's 6 feet of extra on-street parking, both for us and it's not just our side, it's his side as well. And there's actually no reason to have 5-foot wings on this very wide driveway. That's the one piece when I think Kabir was asking, like, do you need this? There's no actual need. It's not, the only thing that does is it takes parking away from the people on the street who are using that every day.
Well, that's an opinion which may not be shared by others, I must say. On whether the aprons are useful with a very narrow street and cars parked nearby. But again, the application explained that he was going to create a driveway that is 15 feet wide and with 2 additional 5 feet wings, creating a 25-foot space on the street. It is 5 feet over the 20 feet allowed, which is why he needed a variance. And he has done all that as specified in his application.
But why is it? But it's not really a 5-foot variance. I mean, the starting point is the starting point for the application is what exists for the existing driveway.
The word replace is in the application.
In the variance that was granted to him, it says existing drivable driveway. And it says the variance is for 5 feet. He was given 5 feet to extend.
Right, from the 20-foot limit that the town sets. That's what the variance is. Otherwise, there isn't a need for variance.
I mean, I think the whole conversation ultimately hinges upon, like, what do you see as existing and what was communicated, what was presented at the town council meeting, what was presented to us with paint what was communicated to us when, I mean, I think we could go on and on and on, but it really does come down to intent. What was his intent? Also, what is that starting
I
point?
mean, we can disagree on that, and I will disagree because I've read the application. But on the point that you were not notified about the action on your side of the driveway, you continue to assert that you were not notified because he has said that you were notified.
I mean, I don't understand how,
You said
maybe
it-
Mr. Kelly can explain how we were notified,
Explain what?
how we were notified. He said when, Kabir said, did you, he said, I marked where the driveway would go, but I think it's very important to listen to every word, but he didn't say I marked their side. So we were notified of where the driveway would expand by showing us with spray paint and with a marker. We were not notified that there would be any expansion on our side,
So,
or that we would be taking those, that 3 additional feet would be taken away.
all right,
Okay, do you have any further questions?
not of Jamie, no.
Okay, thank you. Councilmember Sarko.
Mayor?
But you'll have a chance to rebut, but this is the opportunity for the council to ask Ms. Kaplan questions.
So thank you very much for your comments. Part of the variance that was approved by the council was for a agreement to be signed by both parties. The agreement was not signed. There was no agreement. But my question to you is, if you had known that the apron would cut more into your property area than it was previously, would you have signed that variance?
Absolutely not. There's no reason to
Okay.
take 11 feet of street parking away from the town.
Thank you. That's all I have.
Thank you, Councilmember Howland. Do you have any questions?
No,
Councilmember Kumar.
Sorry, this may be a little, but I just want to.
I mean, it's the theme of the evening.
Yeah. So I want to confirm that in your expectation, let's assume we don't know what the original point was of the driveway, but a variance was granted. In your understanding, it did not require expanding on to 4813.
Right. That was how.
That
it
was your understanding.
Presented. to
Okay.
us.
And then, given that it is constructed now, so I'll ask you the same question I asked Russell. What is your expectation? What would you like the council to consider?
Yeah, so I think there's been a couple of like violations of the variance, and if you read the variance, it says that if it's violated, that you lose the variance and you have to restore it back. So what we'd like to see is for Mr. Kelly to give 3 feet back on each side, on on his side of the property, and for our side to also be restored. So the stones that were out there are exactly where the stones were before they were dug up. I mean, those are the actual stones. We came home and they were like thrown onto our property. And we'd like to have, one of them is not going to be put back because of the curve that changed from coming down to that angle, but the other 2 should be restored, and there's no need to have an apron that large. It should be, the 3 feet should be put back on each side is what I'd like to see happen.
Is that Councilmember Rovak, do you have any questions?
I don't have any other questions.
Okay, thank you. Are there any further interested parties that wish to testify? Okay, Mr. Kelly, now you have a chance to reply, and then we'll end the hearing portion of the hearing. Testify.
Well, to the point that we encroach 3 feet onto the right of way in front of Jamie and Russell's property, that's just not true. The photograph that Ms. Brovack was just looking at with my wife shows 3 stones positioned on the newly placed concrete. And Jamie just testified that those came out of her front easement or front right of way there. And well, in fact, they did not. And as I said earlier, can be deduced by looking at the before pictures with the tree, the stones, the cut of the existing concrete where the radius comes into it. If you look at that and look at the stones, you will see that they've added one stone there. So these two stones are available. Are still there. That's where we started the apron. And those are the two stones that were lifted to make room for the new apron. They've added.
So let's make sure that the town attorney, did you see that?
Can you
Did
pull up
everybody on the council see that?
page 20? Can you share page 20?
My packet only goes to page 18. See.
It's,
Oh, no, here, they're loading. Okay, sorry.
yeah, keep scrolling down.
Okay. So page 23, are we looking at?
There we go. So that's the original.
It's this stone, just to the left of this tree, this stone, come to this joint on the concrete, and that's the joint where we started our apron. And there's only two stones there. Somehow they put three stones down with the radius, which would have projected the driveway out of the screen of this photograph. So if you move to the 2 or 3 pages down, you'll see what I'm talking about there.
So page 23.
Right there.
Yeah.
This radius would continue to be out here, which the existing driveway was not. And I would also add that the right of way is a foot behind the stone wall. And our driveway comes to that point a foot inside the easement. So we're not taking land from them. We respected their landscape and brought the apron in a foot to accommodate their landscape and just connected the wing as directed by the town's engineer. So I did not take 3 extra feet out of their property, and I actually gave a foot of it back here, and yeah, they did have these stones. If you go back to the previous page, previous photograph, you see that these stones come down a little further, but they had to be relocated, repositioned for the apron as detailed in the town spec.
Okay, does that conclude your rebuttal?
I'm sorry.
Does that conclude your rebuttal?
Yes.
Okay, thank you. At this point, the public comment period of the hearing is completed and the record is closed. I will now turn it over to the council president to lead the discussion and if there is to be a decision. But I would like the town attorney to frame what the options are for the council in making a decision.
Sure, Mr. Mayor. I've been debating on options myself as the hearings progress. So one option is to find that the variance has been complied with and not require any abatement action. However, I'm troubled by the fact that a condition precedent was not satisfied for issuance of the permit, and that is the execution of the right-of-way use agreement. And I believe I stated at the prior hearing that that would need to be negotiated and signed by both parties because there was work involving the shared apron used by both property owners. And, the town does not want to get into a debate as to what the shared driveway easement requires or does not require. And so that difficulty was resolved by the apparent consent at the last hearing to enter into that agreement. Appears to me that that agreement is no longer a possibility. So I don't think the town has the option of finding compliance outright because that condition hasn't been satisfied unless the council were to eliminate that condition retroactively. The question is then, could the town lawfully do that if that was an option to be considered? Can the town increase the apron in front of the Kaplan's property without their consent. And, it's not an issue I researched or needed to with respect to the last hearing because there was consent at the last hearing for that. But, now if the facts are different, that would be an issue that would need to be resolved, I think. Generally speaking, I can say case law provides that the town does hold in trust for the benefit of the public the rights of way and can improve the rights of way. With respect to modifying an apron with respect to a variance to benefit one or both owners, I'm not certain that the town could compel the Kaplans to now accept an apron that they did not agree with. But again, that'd be an issue I'd need to research. Another option is to revoke the variance because that condition precedent was not satisfied, or modify the variance. And with respect to modifying the variance, I'm trying to locate now the apron standards. The suggestion was that the apron radius could be reduced on the Kaplan side. I want to know whether that is technically feasible, because generally speaking, the 5-foot radius is to accommodate the turning of vehicles. And if you shortened it to 3 feet, it might not operate as intended. That might be a question for Mr. Lohmeyer, but that would require reopening the record. And then another option would be just to have the applicant restore the apron as previously provided and go back to square one. Parties could negotiate a new resolution, given that there is that shared driveway easement agreement between them. Those are the options I've come up with so far, Mr. Mayor.
Okay, well, thank you. So I'll turn it over to the council president to lead the discussion.
Jeffrey and Robert, it might be useful to hear from Doug on that question, on whether it's possible.
Well, that's,
you open the record and just get it.
okay, Mr. Town Attorney, how would we do that?
Yes, yeah, the council could reopen the record for the limited purpose of inquiring with the building permit administrator whether the town's driveway apron standards would allow a reduction of the 5-foot radius for the to 3 feet.
Okay, so a council member can make a motion, it could pass, and then what is the requirement for the participation of the parties?
Yeah, and then all parties would have the opportunity to testify on that point.
Okay. Here's your answer.
So motion to
Reopen.
ask for Ron's.
So it's to reopen the hearing to allow.
Reopen the hearing to allow the building administrator weigh in on reduction of the said apron by the radius by 3 feet.
Mr. Town Attorney, was that sufficient?
Yes, Mr. Mayor.
Okay, is there a second?
The one open?
So the motion fails. I'll have a second.
No,
Okay, I'll turn it back over to.
Right, okay, so this is a little bit entangled, so I'll try to disentangle it as best I can. On the easement issue, the parties have not signed an agreement on shared use of the driveway. And under those circumstances, does anybody feel that they cannot come to a decision on the variance application at this point?
What's the question we've come to a decision on?
Well, we've got to decide whether Mr. Kelly has complied with the variance.
Sure, I can say he did not. It's pretty simple.
Yeah.
Yes, I can come to a decision.
So that's even without the decision on the easement.
No, I think if I may weigh in, I believe the condition precedent wasn't met. There's a reason we established that because we anticipated similar challenges that wasn't met. And so as a result, I think the variance is in violation, we are in violation of the variance. Well, simply not in terms of the technical deployment of the driveway, But given that that was the condition set for the variance, that condition was not met. And as
Not met.
Steve established, if that letter would have been circulated, most likely this would not have been the end.
So I could, let's just say for argument's sake that that is not part of the variance request. The easement was a separate thing. The
Wasn't it a
variance.
condition though?
But it is a condition, so what do you mean, let's just say?
Is it, all right, that's the, I don't know, is it a condition of our, it's in the text here somewhere.
Yes, it's paragraph 1 under grant of variance. Before the town manager issues a building permit for the construction, the applicants must have a valid Montgomery County building permit in accordance with plans submitted for the record, if required. And the applicants and abutting neighbors must execute a public right-of-way use agreement in a form approved by the town.
Well,
And
that-
that
that's-
relates back to finding of fact number 6, which noted, 2 town residents opposed the request. The concern about ADA compliance can be addressed with a revocable public right-of-way use agreement, confirming that in the event the town needs to make use of the subject area of the street where the gravel driveway is approved, the gravel must be removed by the owners.
All right. Yeah, I
Just by the letter of
Yeah.
how we established this, it wasn't.
I see that as part of the permit approval, but not part of the variance myself. In other words, that the variance was particularly to get an exception to the 20-foot limit for our driveway aprons to go to 25 feet. And that's what we were voting on in August.
Paul,
But Robin, if that is true, if indeed it's true, the letter was still not signed, right? And
Right.
so they are in violation of either, they are a bigger violation.
I
according to you, which is
agree.
they're in violation of the
I agree.
permit.
I mean, this question, can we make any progress tonight is
Well,
what I'm trying to
because
get
in
at.
violation of the permit, that's a bigger
I feel like
deal.
we're going in circles for a ridiculous reason. It wasn't in agreement. They didn't sign it.
Right.
It's over.
No, I think Robin is making the point that is it attached to the overall permit or is it attached to variance?
Right.
In my humble opinion, if it's attached to the whole permit, we have a bigger problem. I believe it is applied to the variance and as a result, the variance was not, is not, has not been executed as we intended.
is that, so,
Do you agree with that?
No, I don't actually. What I read is that it applies to the whole permit and they are in violation of the whole permit, and that's a different process altogether. And where we are now is in terms of just deciding the variance. I hope that they can come to agreement and they'll take care of that.
Can we ask Ron? You think it's one thing, we're talking, some of us think it's another thing. So Ron, is Robin right or wrong that this reverts back to the whole permit, not the variance? The violation?
Sure. So the town council could amend the variance. The variance could be amended to remove the requirement for the right-of-way use agreement. But my concern is I'm not convinced whether or not the town has the authority to allow one property owner to build part of a driveway apron in front of the property of another person. So in that case, the variance could be modified, the condition could be removed, the 25-foot apron variance could stand, but it would have to be located, any expansion would have to be located entirely on the applicant's property.
That's an added.
Right.
That's a different direction, right? Ron?
So sorry, Councilmember Heller, the short answer is, I think the requirement for a right-of-way use agreement is a condition of the variance. And it was made a condition of the variance because this is a situation where we've got 2 property owners involved.
All right, well, I'll accept then that it is conditional of the variance. Does anybody see whether we can make any progress at this point in time then?
If it's, so if it's a condition of the variance, then it hasn't been met. So it's in violation of the variance.
Right.
I think this is, so if I may speak for a moment, they're in violation of the variance that we approved. I know that when I voted because, and I think it was just a vote of 3-2. I voted to approve the variance Because one, it would have no impact on the neighbor's property. Two, the neighbors supported it. And three, there was going to be a signed agreement between them to make sure that there were no issues. And I would not waste an hour and a half of my life here. I think that they need to remove the apron.
And just to
What
be
they
clear-
put back in, maybe we have to come back and talk about that some more, unfortunately. They need to take that out. I think it's very simple. They violated the variance, they need to restore it.
And just to be clear, I think the neighbors, as we established, supported it because they did not understand or believed that the expansion would not encroach on their end of the property, which I think was an understanding I had as well going into it, that there would be an expansion, but how it would be executed would not encroach or diminish.
My
That's
understanding here is that they have not expanded the driveway onto the Kaplan's property. They have kept it within the.
No, you're right. It's not their property. But it is in front of their house. It's the right of way. It has changed the edge of their entrance of their home as they had understood it for a while. So that's just, we can be more legalistic about it, but fundamentally that end of their property was disturbed. That was not their understanding. I don't think it was our collective understanding either. Even though we understood that there would be value in expanding the apron, because it's a shared driveway, we understood it would be I actually thought it would be on one end.
Well,
Right.
it sounds like Council Member Circo is prepared to make a motion.
Right, and we might amend it, but my motion would be that we. I'm not quite sure, maybe Ron needs to help here. I don't know if we find that there's a violation of the variance.
Circo craft
And
a
we
motion.
find that the variance, that the applicant is in violation of the variance granted. That's what we.
Well, what are the why don't you explain to Ron what you want to
So-
accomplish?
There are a couple of steps here, maybe provide some guidance, Ron, to guide discussion. I believe that the apron that was installed needs to be removed. Well, I believe that the variance was not
Find them in violation.
the violation of variance, the apron needs to be removed. And now that I understand what the driveway situation is, I would not approve a variance of past 20 feet. I think 20 feet is large enough for that driveway. That's 6 more feet, curve it, nice, whatever, and do not touch the neighbor's yard. So
So-
that'd be my
So
desire. I don't know
Ron,
how
can
to
you
frame that.
craft a motion?
Yes, but I apologize for making this more complicated. So the variance was for 3 different variances. So we have to decide whether the 2 other variances can
Ah.
stand or not.
I'm just talking
So-
about the apron.
Okay. So yeah, if the existing shared driveway variance stands, then that's allowed to remain with the additional 5 feet of width, which is just on the applicant's side, as I understand.
Yes.
And then the other 2 variances, one, a portion of the driveway in the right of way would be made of gravel. So the applicant, as I recall, sought that variance to appease the neighbors, where he preferred concrete. So I guess you're saying that variance can stand. Um, And then the motion would be to revoke the second of the 3 variances, which was a variance of 5 feet for the shared driveway apron. And the applicant is instructed to restore the apron to its prior condition or seek additional approval for something else.
Is that? That's okay.
And just to clarify, Councilmember Circo, are you okay or not with the apron remaining in place until the applicant comes back? Or does the council want to compel removal in the interim or restoration in the interim?
No, I think it's fine for us to go through another iteration to have the solution figured out before we do the removal.
Okay, then I would suggest adding to the motion a deadline for a new application to be submitted.
A deadline of 60 days, 90 days? I don't know.
Yeah,
what it is.
sounds
So
good.
30 days.
30 days.
30 days.
Okay, so
So the deadline would be 30 days to submit an additional application or to restore the apron to its prior.
Exactly. Okay, so why don't you restate the motion so that I can.
Yeah, the motion would be to revoke the second of the three variances. That is the variance to allow 5 feet for the apron width. And the applicant is instructed to submit a application for another apron within 30 days or to restore the apron to its prior condition.
Yes,
Okay, so second.
yes.
I saw Howard first. Is there discussion?
Yeah.
And I'm sorry, one other point, Mr. Mayor, and to instruct the applicant to sign and return the water drainage maintenance agreement that was required for the building permit of the other improvements from
Okay,
May.
okay, Mr. Councilor Survey, do you accept that?
Yes, thank you, Ron.
And you,
I accept
Okay, now
the water
discussion.
drainage. Yeah, right. I do not support the motion. The written application, which we all had access to at the beginning of August and presumably all read, says that he would construct a new apron 15 feet. The extra feet are on his own side, and with additional 5-foot wings on each side. So in other words, the 5-foot wings were specified on each side, and he has done that. So he has complied with the application that we supported in August. Where there is a sticky point, and there is a sticky point, is in whether he ever notified the neighbors that this particular application would require moving into the easement that they considered part of their property, really.
And which was a condition we set. That's the bigger deal. We established a condition tied to the variance, which we reconfirmed with the lawyer. That condition wasn't met.
Which condition are you talking about?
That there would be a signed easement
Right,
agreement.
no, right, yes, so
It's not just that it shouldn't be done, we actually established a condition that they would need to meet.
yes, I agree there.
So that alone means that the variance is in violation of the variance, right? Why are we complicating?
That's because I don't agree with the motion as written, because Steve is saying that the apron should be ripped up. I'm saying no.
What would be a
I'm saying I don't agree with the variance because they have not agreed with each other on use of the driveway. That's the only reason.
No, but just, I think you.
Well, the
would
right of way,
outcome be the same?
the
Go
right
ahead,
of way use agreement
But
does not indicate the agreement between the parties on how the driveway is to be used. It is an agreement that provides the Kellys and the Kaplans understand that this is public right of way, and we're only allowing the gravel until such time as the town wants to put in an ADA compliant sidewalk. So they agree that their use is subject to the town's right to reclaim it in the future for an ADA compliant sidewalk. Just if that point was not clear.
okay, so that actually is irrelevant to what we're talking about then.
Well, it's only relevant to the extent that because that condition wasn't met, they are legally in violation. of the variance.
I agree they're in violation right now for that reason.
And so
But
then
the
after that,
issue
we
is, but is
revoke.
there anything left of Steve's motion is what I'm trying to say. In other words, do we say anything about the fact that they have clearly not agreed on use of the driveway at this time because Russell Green and Jamie Kaplan believe that part of what they consider their property has been violated by the driveway, even though the driveway is complying with the variance.
I don't know what we're talking about anymore.
So did you wish to, so there's a motion on the floor. Did you want to amend the motion?
I'm going to try to.
Robin, you may want to explain again, because it's,
Well, let's see
Might
if
be
he has,
splitting
let's see if he has,
hairs.
let's see if he has.
you know what I mean? Like, condition wasn't met, you're in violation of the variance, and as a result, we revoke.
Yeah, right, it's the issue of the language we're using. Steve, would you restate your motion?
I'll let
Well,
Ron
understand.
Thank you, Ron. I'm glad you're here or there.
Yeah. The motion was to revoke the second of the 3 variances granted. That is the variance for 5 feet for the apron width, and to instruct the applicant to either remove the apron and restore it to its prior condition, or submit within 30 days an application for a new configuration for the council's consideration, and to submit the water drainage inspection and maintenance agreement.
So given that, Mr. President, did you? do you
Yeah,
wish to make an amendment?
I would amend the language which says the 30 days, the new plan, or remove the apron to instead obtain agreement with the neighbors on the driveway, and any changes to it that will be required by that agreement.
Okay, so that's the amendment. Is that legally and technically sufficient?
Can you just say that again, amendment, sorry?
Yeah, so that it becomes to agree with the neighbors on the apron, basically on the apron, and any changes that are negotiated with the neighbors. That's what it comes down to.
I'll second it so that we can discuss.
Hold
Well,
on.
yeah,
Is that legally and technically sufficient, Mr. Tenenbaum?
it is, Mr. Mayor, other than you can't compel parties to reach an agreement. So we would have to have a second clause to reflect what would happen if an agreement can't be reached.
All right. Um,
So is there a second on the amendment?
There's a second, so we can
Okay,
discuss it.
discussion.
Yeah. And Robin, I think it would be good to step back. What are you trying to solve for? Would be good to.
Well, I'm trying to do 2 things. One is to save us, because we did agree to the plan that Mr. Kelly stated in August, which was to have a 25-foot apron.
Yeah.
Now, the problem, as it has transpired, is that the Kaplans did not understand that that apron would extend into the easement section, which they have hardscape, and they consider part of their territory, what it boils down to.
Just to be clear, a lot of council members also did not understand that, in part driven by the way the testimony was given at that time. The way that testimony was given, not deliberately to obfuscate or misguide, just the way it transpired, I think we came to a different conclusion, even on our end.
All right, but how do we get out of that? Is what it comes down
There's
to.
nothing to get out of. There was a variance.
So can I offer some comments? Councilmember Barr. So I found the town's standards for driveway aprons, and they reflect that the turning radius is a 5-foot maximum. So it is possible to have less turning radius. So I just point that out to you because it is something the parties could consider. The parties could consider reducing the width of the truncation. So that's, could be for them to discuss, but I just wanted to put that before you because it wasn't
Okay,
an issue we were talking about.
Is there further discussion on the amendment?
Yes, I think that amendment, I think I understand the motivation. But I think it's unnecessary in that we deny the variance or we find that they're in violation. If they wish to proceed, they're going to have to come back to the council. And they're going to have an agreement with the neighbors, or they'll not have an agreement, and then we'll hear both sides giving different positions. But it will work itself out.
We need a second clause to the.
I don't think we need to complicate this
Okay,
further.
is there further discussion on the amendment? Hearing none, all those in favor?
Well, hold on a sec.
No, all those in favor? All those opposed? Okay, the amendment fails. So now we go back to the original motion unless anybody wants to amend it.
I just want to repeat it again.
Ron? Yes, excellent. Mr.
Yes,
Jones.
the motion would be to revoke the second of three variances, that is the variance for 5 feet for the apron width, and to instruct the applicant to either remove the apron and restore it to its prior condition, or submit within 30 days an application for some other solution. And to submit the water drainage inspection and maintenance agreement that was due with respect to the prior building permit.
Okay, is there further discussion?
One quick question. Oh, go ahead.
So does that mean that they could just cut off that apron part on the ones on the Green Kaplan side?
But remove everything immediately or come back to us with plan for you or something new.
Okay.
Okay, is there further discussion?
I have a quick question. Do we need to say the reason for why we are revoking
Ask the town attorney.
in the motion?
Sure. So the reason would be is that the condition precedent for issuance of the permit under the variance was not met, and that was the negotiation and execution of a right-of-way use agreement to be signed by the applicant and the Kaplan Greens.
Or is that an amendment or do we all accept that?
It doesn't need to be part of the motion.
Okay. Is there further discussion on the motion?
Well, yeah, I'm gonna bring up that clause doesn't specify anything about the width of the driveway, so I'm still not happy.
Okay, thank you. Is there further discussion on the motion? Hearing none, all those in favor?
Aye.
All those opposed?
Opposed.
Are you very, okay, thank you. Thank you very much, everybody.
That was 4-1, Mr. Mayor.
Yes, sir.
Thank you.
And so that concludes the hearing, and thank you to all the parties and to the council. And now I would like a motion to adjourn the council meeting.
So moved.
All those in favor? Aye. And now I'm calling to order the town council work session. And I'm